If AB 1757 were to become law, it would be an absolute gold rush for California plaintiffs' lawyers. And so on the screen with me is a document. The title is AB 1757 Millionaires. California plaintiffs' lawyers would feast on new legislation. And so the reason why, all we have to do is look to the bill language itself. It is broad, far reaching, subjective, and it incorporates WCAG 2.1 AA without qualification. So what that means is more people can be sued, a wider range of assets, digital assets, is at risk, and it's easier to make a claim of inaccessibility and therefore non-compliance with the law. So, as it stands, plaintiffs' lawyers in California are already doing quite well. There have been a few recent decisions in court that have now basically limited California plaintiffs' lawyers to websites tied to physical locations. However, they're still printing money. For every case that is settled, the settlements are usually ranging between $5,000 to $12,000 in California. With this new bill, only one technical deviation from WCAG 2.1 AA could potentially is needed to potentially give rise to litigation. So if a website were non-conformant with WCAG 2.1 AA, the plaintiff's law firm could argue that their client either experienced plaintiff to encounter a barrier that caused plaintiff to experience a difference in their ability to access the website compared to other users, or in the alternative, they could argue that the plaintiff was deterred from accessing all or part of the website or the content of the website because of this non-conformance. So those are two very subjective ways to establish a cause for statutory damages, and that is difficult to defend against. Um, it's difficult to defend against that level of subjectivity, which is baked into the legislation. Again, we look at caused plaintiff to encounter a barrier that caused plaintiff to experience a difference in their ability to access the website. So plaintiff's experience. Alternatively, plaintiff was deterred from accessing all or part of the website or the content of the website. So again, whether or not someone is deterred is really up to that person. So it's subjective. So it's very difficult to defend against that level of subjectivity. And I'm going to now read through, I'm going to scroll down, I'm going to read through some of the language from the bill. Internet website includes all internet web-based technology, including but not limited to a mobile application that can be accessed by a mobile device. So setting aside that mobile apps include native mobile apps and hybrid mobile apps, which aren't web-based or completely web-based, that is very broad language. So all internet web-based technology, and it's including but not limited to mobile apps. Also, continuing on, it is unlawful for any resource service provider in exchange for money or any other form of remuneration to intentionally or knowingly construct, license, distribute, or maintain for online use an internet website that fails to comply with the internet website related accessibility standards. So that fails to, and it should be conform with the Web Content Accessibility Guidelines version 2.1 conformance level AA. So you can see now how any nonconformance, any deviation from those technical standards could give rise to litigation. Also, resource service provider is defined as a person or entity that, in exchange for money or any other form of remuneration, constructs, licenses, distributes, or maintains for online use any internet website or resource to be used within or in conjunction with an internet website. So notice how that language is extremely broad and extremely expansive and extremely inclusive of so many potential digital assets or integrations and so many different people who are involved in these with these digital assets. So it's not just the website, it's not just the mobile app, it's not just the other digital asset. It's everything that's used within or in conjunction with it. So this language is extremely broad, and it's really, really welcoming, favorable to plaintiffs' law firms. And with any new law, um, we don't we don't need to enrich plaintiffs' law firms to make digital assets accessible. What we need to do is we need to set a precedent. So new legislation is needed. AB 1757 is at, as it is currently written, is 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 insufficient. It's a bad proposed law. We need legislation that sets a precedent, that provides notice, that is written so as to prevent serial litigation, and only encourages genuine claims of inaccessibility. As it stands with this law, with this proposed law, hundreds of millions of dollars would go to plaintiffs' law firms, and that money could go to accessibility. So we need to leave plaintiffs' lawyers out of the equation, and we definitely don't want to enrich plaintiffs' law firms in the name of accessibility. They really don't need to be a part of the equation, but what we do need to have is a formal precedent. And so any new legislation needs to be written carefully, and constructed carefully, so that we're not inviting litigation in mass, which is currently the situation we are in. But this bill, if it became law, would only exacerbate that. So this bill is potentially a gold rush for plaintiffs' law firms, and that is why this should not become law.